This video is going to discuss domestic violence and the lawful protections that a tenant or co-tenant that's the victim of domestic violence has. First of all, the definition of a domestic violence is that when there's specific unlawful acts committed by a person against a spouse, a former spouse, a blood or marriage relative, a current or former dating partner, someone with whom they've had a child with, or a minor child of any of those individuals, or the person's own minor child or legal guardian. The acts that constitute domestic violence in Nevada are battery or assault, coercion, sexual assault, stalking, arson, trespassing, larceny, destruction of private property, carrying a concealed weapon without a permit, injuring or killing an animal, burglary, invasion of the home, pandering or kidnapping, false imprisonment, or any attempt or solicitation to commit any of the acts listed above. Under NRS 118A.345, victims have a right to terminate their lease. However, they must give written notice to the landlord, and that termination becomes effective either at the end of the current rental period or 30 days after the notice is provided, whichever is sooner. They must send that notice within 90 days of being the victim of domestic violence in order to exercise that right. They must have a notice that describes the reason and include either a protective order, a law enforcement report, or a signed written affidavit by a qualified third party, which could be a licensed physician, psychologist, social worker, somebody who works in domestic violence centers, or specific clergy, and they must all be licensed or located in Nevada in order to be a qualified third party. The terminating tenant or co-tenant is only liable for rent owed through the date of termination and other outstanding prior obligations. The landlord cannot withhold a security deposit simply for early termination. The person named as the adverse party can be held civilly liable to the landlord for any economic losses resulting from that early lease termination. The tenant or household member can require the landlord to install a new lock or rekey the dwelling at the tenant's expense. The landlord must refuse to give a key to the adverse party and deny them access to reclaimed property unless accompanied by a law enforcement officer. The landlord is prohibited from providing the adverse party with information regarding the tenant's new whereabouts. Furthermore, current landlords cannot characterize or disclose the event as an early termination to prospective landlords. A memory aid is safe lock. S stands for the 90-day requirement. A is the adverse party liability. F is the financial protections. E is the effective date, which is 30 days after the written notice. L is the law enforcement or legal proof. O is out of sight or the privacy rule. C is changing of locks. And then finally, K is key refusal for the adverse party. As always, best of luck in preparing for your exam.